Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice, to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
The IP 101, The Fundamentals of Intellectual Property for the Startup Sector is a webinar organized by the European Chamber of Commerce of the Philippines and its Intellectual Property Committee in partnership with IP SME Helpdesk.
We would like to acknowledge our corporate partners, as well as our premium members. Here are some gentle reminders before you officially start the webinar. The moderator will allot time for a question and answer portion. Please use the Q&A box in your Zoom platform if you have any questions. No other recordings in any form are allowed once you enter the webinar. Copyright 2021, all rights reserved to the ECCP.
Okay, a pleasant day, everyone. Thank you for joining us at this webinar entitled IP 101, The Fundamentals of Intellectual Property for the Startup Sector. I am Attorney Divina Ilas Panganiban, and I am honored to be your session moderator at today's interesting and hopefully educational event. I currently chair the IP Rights Committee of the Chamber, and on regular working days, I work as a partner in Casumbing Torres Law Office, a member firm of Baker McKenzie International. I'm a partner in the Intellectual Property, Data, and Technology Practice Group, and I co-head the Technology, Media, and Telecommunications Industry Group in QT. So this event would not have been possible if not for our event organizers, the ECCP and the Southeast Asia IPR SME Helpdesk. I would like to take this opportunity to thank everyone for joining. We are headed for a truly interesting dialogue today. So to start off the program, please join me in welcoming Mr. Gerry Constantino, ECCP Director for Projects, Events, and Trainings, for his opening remarks. Mr. Constantino, you have the virtual floor.
Thank you, Attorney Divina. To our colleagues from the Southeast Asia IPR SME Helpdesk, our speakers, ladies and gentlemen, welcome to today's webinar. This webinar is jointly organized by the European Chamber of Commerce of the Philippines and the Southeast Asia IPR SME Helpdesk. We're very glad that you're all joining us today. Among the positive effects of the pandemic is the increase in startups as well as the rapid shift towards innovations driven by individuals as well as businesses. In support of this, a number of initiatives have been forwarded by various stakeholders, including the Philippine government, international and national organizations, as well as educational institutions, among others. Indeed, startup creation, driven by innovation, plays a critical role in the fast recovery of the Philippine economy. One of the manifestations of the boost in innovation in the country is the growth in the Philippines startup ecosystem. Metro Manila made it to the list of the top 100 emerging startup ecosystems in the world, according to the Global Startup Ecosystem Report 2020 of Startup Genome. The startup ecosystem was valued at $1.6 billion in 2020 from only $375 million in 2019. It is worth noting that the Intellectual Property Office of the Philippines has recognized the role of startups in kickstarting the economic recovery through jobs creation and spurring innovation. To support startups, DTI is implementing enabling policies and strategic support programs for enterprises. In particular, DTI is aggressively promoting the digitalization of business operations and the digital transformations of MSMEs and large enterprises. Through the Innovative Startup Act, the DTI is working closely with the Department of Science and Technology and the Department of Information and Communications Technology to facilitate more collaboration among members of the startup community to support the scaling up of startups and to promote their global expansion. To maximize the opportunities brought about by this momentum, as well as to protect innovations introduced by startups, it is crucial that companies understand intellectual property or IP and develop an IP strategy that aligns with the business core. For this reason, we're happy to present to you in today's event a platform for discussions on maximizing startup business growth, sustainability, and competitiveness in the market with the help of intellectual property. This will include a walkthrough of IP's role in the sector and how IP infringement may be addressed. This event will also showcase the work that has been done by several startup leaders and stakeholders in the country's startup ecosystem. To this end, we encourage everyone to actively participate in the discussions today. Having said this, I once again welcome and thank you all for joining this webinar, and I look forward to a productive session ahead. Maraming salamat po.
Thank you very much, Gerry. That was a perfect introduction, which truly sets the tone for our discussion this afternoon. Likewise, we are all excited and are looking forward to the interesting exchanges that will take place today. At this point, we then proceed to the presentations and discussions from our resource speakers. First, we have Attorney EJ Baranda representing the Southeast Asia IPR SME Helpdesk. To briefly introduce Attorney EJ, he is an IP lawyer in the Philippines with over 10 years of experience. I question this because it's probably 20 years already by now. He has a background in molecular biology and biotechnology and is a qualified patent agent. Edmund has handled the prosecution of local and international patent applications and is highly regarded by clients who value his practical and quick approach. EJ has extensive experience in drafting of patent specifications, advising on freedom to operate searches and prosecution of local and international patent applications. He has also been involved in patent litigation, particularly patent cancellation and patent infringement actions in the pharmaceutical field, and trademark or copyright litigation. He has vast experience in search and seizure operations. EJ is a member of the IPP of the Philippines and the New York Bar. He obtained his bachelor's degree in law from the University of the Philippines and LLM from the University of Michigan Law School. EJ joined the Helpdesk network in October 2013. EJ, you now have the virtual floor. Welcome.
Thank you very much, Rina. Again, it's good to be back here at ECCP's webinar. I'm always happy to speak about IP. Binisto mo naman ako. I think let's just stick to 10 years of law practice, Rina. But anyway, before I begin my talk, I just want to promote again the IP SME Help Desk. I mean, if you listen to the video earlier, I think it already gave a background on what we do. But just to emphasize or to reiterate, the Southeast Asia IP SME Help Desk is an initiative of the European Commission, and the objective is to help Europeans SMEs to protect and enforce their IP rights in Southeast Asia. I'd like to emphasize that all our services are free of charge for EU SMEs and intermediaries. You will see on the slide some of the range of services that are offered by the Help Desk. First, we have an inquiry helpline, wherein you can send through any IP questions in relation to Southeast Asia, and you expect to receive a reply within 3 working days. We also organize monthly training workshops and live webinars, so including this one, which is tailored to the needs of the SMEs. Please, we also have a newsletter, so we'd like to encourage everyone to subscribe to our newsletter and then connect with the team on social media as well. We also give you a wide range of publications in terms of country fact sheets, industry-specific IP guides, or general IP guides on various topics. And you can all access this through the website of the help desk. And finally, we also offer interactive learning tools. So for example, an e-learning module, which is also available for download from our website. All right. So I was asked to talk about IP fundamentals for the startup sector. This is really not meant to be a comprehensive crash course on IP, because I was only given 15, 16 minutes to talk about this. But I'll try to cover as the relevant parts. My objective is for you to be aware of IP and to be aware of the IP issues that you may face as a startup company. I will be discussing 4 topics. First, we talk about the assets of a startup. What are your assets? So because before you can protect your IP, you need to first identify what your assets are. So once you've identified your assets, then we can talk about the kind of or the type of IP protection that you will need. Third topic is very important: IP ownership, especially for a startup company. In the beginning, you don't know who will own the company. You don't know who will be the stockholders or who will be the partners in your startup companies. It's important to identify who is going to own the IP that you will generate or you will license. And then I have one slide, and I think this is already mentioned by Gerry earlier, the Innovative Startup Act, which is very relevant to obviously to startups like those of you in the audience. So I'm going to talk about some of the relevant provisions there. All right. So what are the assets of a startup company? In the slide, you can see I outlined about 5 assets which I think are relevant to startups. The assets of a startup company will really depend on the stage of the startup company. So you have pre-incorporation stage or pre-registration stage if you're not gonna incorporate a corporation. And then of course when you've already registered, and then the third stage will be, I guess, when your company is up and running. So at those various stages, you accumulate assets, you generate assets as well. So it's important to identify what your assets are per each stage of the startup company. So there are, of course, the first asset that I would like to discuss is ideas. I think most, or if not all, startups start with an idea. You want, let's say, you wanna develop a new app that will be that you can of course sell to companies. You want to develop a website. You want to develop a new software that you wanna peddle and customize to certain clients. Let's say you want to outsource, you want to provide an outsourced service. So it starts with an idea, and can you protect an idea, which I will discuss later. Another asset of a startup, of course, products, processes, and know-how. So that's when you translate your ideas into actual products, actual processes, and know-how. So that means that you've already developed or accumulate or developed enough information or accumulated enough information for you to have know-how, and this know-how can now be, you could offer this as one of the services of your startup company. In startup jargon, we call this a value proposition. What's the value proposition of your startup company? Another asset of a startup company, which is at the middle stage, which is when you've already registered your company or registered your sole proprietorship. You're just about to register your company or your partnership. Your company name is also your startup. So what company name are you going to use, and what logo do you want to associate with your company? So that's an asset of a startup, and it's also crucial, as I will explain later on. And of course, if your startup company provides products and services, you may want to brand those. You may want to have a mark, a trademark, or a logo associated with your brand or your service. So that's something as well. The decision your decision to name your product or service a certain mark is also very crucial and also very important. And protecting that brand is also crucial. The last one is not so obvious. Other companies' assets. I know that most startups they generate their own products, they generate their own processes, but some startups are actually in the business of distributing the products and services of other companies. So that also becomes part of your assets, and that will be under a distributorship or a licensing agreement. Okay. All right. So now I've discussed or identified some of the assets of a startup. Perhaps that begs the question: why do you want to protect your IP in the first place? You need to protect your IP on those assets that I mentioned because it's a protection against infringers. The only way you can enforce your ownership of of the IP in those assets is if your IP is registered, with some exceptions I will explain later on. So if you have registration for those IP, then you can enforce, you can sue, you can ask for an injunction, you can prevent your competitors from using your products and your services without your authority. It's also crucial to protect your IP because as a startup company, I understand you want investors to come in, you want companies, entities, individuals to support your company. And one of the first things that they will ask these investors, this possible investor, is, are your IPs protected? If I invest in you, will I be able to get my money back? Will I earn revenue from my investment? And if your IP is not registered, then it's unlikely that you will get to attract these investors, because then it means that they will not be protected against competition. They will not be protected against infringers. Okay. Okay. Ideas. So how do you now protect your IP? So ideas, let's talk about ideas first. By definition, it is not an intellectual property. And in fact, it is excluded from protection under the IP code. But is there a way, if it's not protected under the IP code, is there a way to protect your ideas? The answer is yes. You can protect your idea under a contract. And it is very crucial in the pre-incorporation stage or at the very early stage of startup companies. That's when you start talking about your wonderful ideas for your startup company, for your business, and then you discuss this with your friends, with your family, and maybe a serious discussion with a possible investor. Now, these ideas are easily stolen, and I'm sure you've heard of brilliant ideas being stolen by unscrupulous individuals, and you don't get any credit for that. And worse, your startup company becomes obsolete because those valuable ideas were stolen. So how do you prevent that from happening? Every time you discuss your idea to a possible investor or someone who's just really interested in joining your startup company, it's best to make them sign a non-disclosure agreement or a confidentiality agreement. I understand in practical terms, this may not be always possible or feasible because there's an imbalance of power sometimes. I mean, you're a startup company and you're talking to a big investor. They may want to dictate how the negotiations will run. But I still think that you should insist on an NDA or a confidentiality agreement because, again, these ideas are the seeds of your IP assets later on. It could be an idea that could lead to a patent. It could lead to a copyrightable subject matter or even know-how or trade secret. Okay. So ideas, again, like I said, not protected by IP, but there's a way to protect it through a contract. What if your asset is a product or a process and a know-how? There are several options on how you're going to protect your product, your process, and your know-how. First is through patents. It applies to, and I will explain later on what a patent is. So you can also have patent-like protections for technologies that are not as sophisticated as a patentable invention. So it's called a utility model registration. If your product is a design, you could register for an industrial, you could have that registered as an industrial design with the IPO fin. If your products are literary works, artistic works, you could protect that through a copyright. And then finally, trade secrets. These are it could be products, processes, or know-how that you don't want to register for one reason or another, and I will explain later why. There's some advantage sometimes in not going for a patent or going for a copyright registration, for example. Okay, so let's tackle patents. So again, if your asset is a product, a process, or know-how, you could protect that as a patent, and you can patent inventions. And an invention is defined as a technical solution of a problem in any field of human activity, which is new, involves an inventive step, and is industrially applicable. I want to emphasize technical solution because you have the solution that you're presenting to solve this to solve this human problem. Let's say hunger. Let's say the need for connectivity. So it's or the need to certain business processes that you want to make more efficient, etc. The solution that you're presenting for it to be patentable must be a technical solution. Okay, and then the three requirements are: it's new, it's novel. It means that it has not been made available to the public anywhere in the world. A very crucial requirement, because a lot of excited startup companies make the mistake of making available already their products before getting patent protection. Unfortunately, that will destroy the novelty of your invention, and that means that you can no longer patent it. There are some countries like the Philippines with that has a 1-year window period, but then there are countries that do not observe that 1-year window period. So whenever startup companies approach our firm, or we always ask them, hey, if you've developed any patentable invention before you even consider publicizing that, talking about it, let's file a patent application first. The second requirement is it has to involve an inventive step. It shouldn't be the technical definition is not obvious to a person skilled in the art. An easier way to understand it, it has to be tricky. It has to be something that a person who has skills in the art will not be able to think of immediately. So it's the definition of how you evaluate inventiveness really depends on the industry. But again, the word that we use is it's tricky. It's not a simple solution. It's something more complex than that, than a simple solution. The third is the easiest. The third requirement is the easiest to comply with. It's industrially applicable. That means that it's useful. It has a practical purpose. Okay. The beauty of a patent is that it has very long protection for 20 years. But it's not renewable. But I think 20 years is sufficient for you to commercialize your invention and of course make money out of it through royalties and licensing fees. So what are some examples of a patentable invention? Let's say if you're in an agricultural industry, it could be a new biofertilizer. Let's say now with COVID-19, who knows, you're one of those startup companies who are able to develop a COVID-19 drug. I understand that Lagundi is now being studied by some scientists. Lagundi, as you know, is a medicine for cough, and some scientists are looking at its effectiveness to treat COVID-19, because as you know, some of the symptoms of COVID-19 would be respiratory infection. So who knows? They may hopefully they are able to prove that it does work. I want to emphasize that a patent can also be on a process. So let's say you're in a construction industry, you have a new method for installing concretes to reduce cracks. That new method can also be patentable. Okay. Now, what if so where do you patent? This is a business decision. First, you need to identify where you intend to distribute your products, or where you intend to provide your service. If you think you're going global, you're not just looking at the Philippines, we would suggest that you consider filing an international patent application under the Patent Cooperation Treaty. I think right now there are about more than 250 countries that are members of the PCT. So with one patent application under the PCT, you're deemed to have filed a patent application in all those countries. So so again, that's and the nice thing about PCT is that you have about 30 months to decide when to go international. So once you file your international patent application, you have 30 months to shop around for investors, see if you really have a market, let's say in the US or in Europe or in Japan. Then if you think that you have a market there, you're able to develop a market there, and then you have an investor or you have someone who's happy to fund your patent applications in those countries, then you can proceed to actually get a patent in those countries through the PCT. Okay, what if your technical solution or your invention is not inventive? It's still a new invention, a new technology, but it's not really tricky. You can still protect that through a utility model registration. So a utility model, it has the same definition as invention, but inventive step is not required. So it's just novelty and industrial applicability. We usually say that this is applicable for what we call low-level technologies, a technology that may be obsolete in a few years. So a utility model registration will be perfect for that, because after all, the term is only 7 years. And it's also easier to get. In my experience as a patent practitioner here in the Philippines, a registration you could get under 1 year. It's possible for you to get your registration under 1 year. For patent, it usually takes 3 years. So, but again, it has a 20-year term. So you opt for registration if it's a low-level technology. You think the technology can be absolute in a couple of years, and then you want to enforce immediately, because once you have the registration, then you can already enforce your rights over your utility model through an injunction, or maybe you can send a demand letter, etc. Okay. Another kind, as I mentioned earlier, sometimes one of your assets is a design. Let's say your startup company, you are producing new furniture, or let's say you're an app developer or a website developer. So there are certain designs involved in the products that you offer. So that's not patentable, although there might be some aspects of the technology that may be patentable. But if it's just you want to protect purely your design, then what you can opt for is an industrial design registration. So it applies to the novelty requirement, new, original, and ornamental design of an object. So you are only protecting the appearance and not the function or utility, because the function or utility, then that should be covered by a patent or a registration. Industrial designs have a short term, only 5 years, but the good news is they're renewable twice. So you have a total of 15 years to protect your industrial design registration, say for your furniture. Okay. Just to illustrate what industrial design registration, what sort of designs may be registered under an industrial design, is this. These are bottles of, I think you'll be familiar with, especially the one on the left. So that's a bottle design for an energy drink. I think it's specific. It's for Gatorade. So one is not an industrial design registration, though. I mean, unfortunately, I cannot hear you guys. But if you can guess which one is not, the answer is the one on the right, the rightmost. So that's a bottle for Coke. It's recognizable as a Coke bottle, but Coke decided to register it as a trademark, which I will talk about later on, because a trademark doesn't, in theory, it can be perpetual. Your protection for your trademark can be perpetual. All right. Okay. So going back, what type of IP protection is needed for your assets? Now, if the assets of your startup company are literary and artistic works, or you're involved in the publishing industry, you're involved in the could be also design industry. So you have the option of protecting it as an industrial design, also as a copyrightable subject matter. Or if you say you're an IT startup company, your main product is software that you can customize and tailor fit to your clients. So these are protected by copyright. And the nice thing about copyright is it's protected from the moment of creation. You need not even register it. Once you produce these works, then they're already protected from the moment of creation. Although there's some value in registering it, we sometimes advise our clients, if you see that in the future you anticipate that that you need to enforce your copyright, it's always nice to have a copyright registration issued by the Copyright Office, which you can show to the judge. Let's say if you want to go for an injunction, or you want to ask for damages. Okay? So again, some more examples of a copyrightable subject matters relevant to startup company would be, like I said, training. Apart from designs and software, also training manuals. So anything that your company produces that are considered literary, artistic, or scientific works. So those are an asset of a startup company that's copyrightable. Okay. What if your asset is something that you don't really want to disclose? So it's a trade secret, and there are reasons why sometimes the technology that you develop or the know-how that you develop, you don't want to protect as a patent, because the downside of a patent is that you have to disclose it. That means that you have to share it. So your exclusive rights to that technology will really be only for 20 years. But what if it's a know-how that you think can still be used by your company for 20, 40, 50 years? Okay. Then you can protect it as a trade secret. And this is also an alternative if the know-how that you develop is maybe not patentable for some reasons. Maybe it's not really new, but then it's still something that's proprietary. It's still something that gives advantage to your company. Some examples of this would be, let's say, you develop a new machine. The machine itself, the new machine could be patentable, but how to maintain that machine, how to customizing that machine so that it will work for a certain client, that could be know-how, which you need not register as a patent. So there are 3 requirements for know-how or information to be protected as a trade secret. First is it's commercially valuable because it is secret, and by nature, since it's a secret, it's only known to a limited group of persons. And then third is you've taken reasonable steps to keep that trade secret. So through use of confidential agreements for business partners and also for employees. An example I always give for this is the formula for Coke. So especially if you're a startup company that's in the food industry, that's something that you don't want to disclose just to anyone, or you don't want to file a application for let's say for a new food product that you've developed. I think better if you just protect it as a trade secret. The downside of a trade secret is that the laws that penalize trade secrets really do not have teeth. The penalties are too low, and prosecution of a infringement of a trade secret can be lengthy and expensive. So what you may want to do is, whenever you want to reveal your trade secret, say it's part of a licensing agreement, you are licensing the know-how to your customer, to your client, then make sure that in your licensing agreement there's a substantial amount of recoverable damages for breach of contract. And of course, part and parcel of that is to maintain the secrecy of your trade secret. Is you implement mechanisms to protect your trade secrets. Okay. Okay. Next asset, your company name and your logo. you can protect that as a trademark or a service mark. So the name of your company can be registered as a trademark. The brand of your products and services can also be protected as a trademark. So and you can protect if it's a visible sign that's capable of distinguishing your goods from the goods of another person. So in the Philippines, so far we're only limited to visible signs, but in some jurisdictions you can have smell marks, you can have sound marks, but in the Philippines still it has to be something visible. You have to, unlike copyright and more similar to patent, you need to file an application with the IPO. You have to apply for a trademark application, and then the term is 10 years. But the good thing about trademark registration is that you can renew it infinitely. Okay. You also need to remember that you protect your trademark and you want to register your trademark because there are some unscrupulous individuals who may want to ride on your goodwill. So once you've become popular, then once your brands and services your product and services have become popular, then they may want to ride on the goodwill generated by your products and services. So they may try to associate themselves with your brand or with your company. So it's necessary to have that registration so that you can enforce your rights. And for those of you who are not in the Philippines, you can register your trademark here without even establishing business presence in the Philippines. But the downside is we're one of the few countries in the world, I think one of only 3, that require you to show proof of use of the mark here in the Philippines. Otherwise, your registration will be canceled. Okay, and so my tip for those who are thinking of names for their company or for the products and services, conduct an SEC, or that's a Securities Exchange Commission search before deciding on the name of your company, and also do a trademark search before deciding on the brand or for your products and services. Otherwise, you'll get into trouble. Okay, what if your asset is other companies' assets under a distributorship or licensing agreement? Let's say you're a startup company, you want to distribute new luxury products here in the Philippines. You want to introduce into the Philippines new luxury products. You should conduct due diligence before you sign that agreement. Make sure that your principal, your licensor, really owns the IP. There are ways to check whether they really own the IP here in the Philippines. And also make sure that their product is not infringing any rights in the Philippines. Let's say you're bringing in new machines, you're bringing in new technology, you're bringing in a new biofertilizer. Make sure that there are no patents being infringed by that machine or by that biofertilizer that you're bringing in here into the Philippines. You could require your licensor to do that. Let's say, part of the fee, part of the agreement is that they will conduct what we call a freedom to operate search, or you could do it yourself. Okay. Also, since you will be distributing the products and services here, as the products in the Philippines, it's to your advantage if you are given authority to enforce the IP on the owner's behalf. So consider getting that a power of attorney to enforce the IP on the owner's behalf. Okay. Speaking of ownership, one of my last slides, second to last slide. Again, very crucial when you are starting a company. Very clear who will own the IP. Will it be the company that you will form, or the IP will be in the name of the founders of the company? So let's say you're an incorporator, you're the main stockholder. So again, depending on how you want to run your business, you may want to retain ownership, or it could be the startup company. My practical advice is it's better if it's the IP is owned by the startup company, because when you start talking with investors or you want to license, it's easier. Investors or potential licensees find it easier if they're just going to deal with one company, where instead of several individuals who will own the IP. Make sure that anyone that you work with in the startup company, it could be a contributor, let's say a pre-incorporation. You work with some people to help help register the company, or help build the company. or after incorporation, any consultant, any independent contractor, or make sure that you have a written agreement as to who owns the IP that's generated by whatever activity that you hired them for. Obviously, you may want to push that the IP will be owned by your company. Last, employees. So once your company is up and running, you will be hiring employees to work for your company. Make sure that in their employment contract, there's an express acknowledgement that any IP that will be generated by these employees will be owned by the company. Although under an IP code, the default rule is that for both for copyright and for patentable inventions, it's if you do it in the course of your employment, made in the course of your employment, it's part of your regular duties, then it's owned by the employer. But it's just better to be very crystal clear about it, that any IP will be owned by the company, as long any IP generated by the employee in the performance of his duties. Another crucial provision that you need to insert in your employment contract is that any ideas, inventions, discoveries that your employees come up with, they must disclose it to the company, so that the company now will have an option whether to patent it or not, or protect it or not. Also include a non-disclosure agreement. It is when because your know-how, you wanna keep it within your company. So make sure that your employees, because you're not sure whether they're gonna be your employees for life, make sure that they sign an NDA that when they leave the company, they're not supposed to disclose it to their future employer. And also a non-compete clause. And this works both ways. If you're hiring an employee from a competitor, make sure that your new employee did not sign a non-compete clause from your competitor. Otherwise, your employee will be in trouble. Okay. My last slide is again already mentioned by Gerry, the Innovative Startup Act. Pretty new law. April 2019, it was signed, and then the regulations only were released November 2019, so just before the pandemic started. So the Innovative Startup Act created the Philippine Startup Development Program. Mainly, it provides certain benefits and incentives for startup companies. And one of the things that you can and there are three agencies that head this startup development program, which is the DOST, the DICT, and then the DTI. So what they can do is they can provide incentives in participation in local international startup events. There's also a startup eco zone, and most importantly, you have a fund, the Startup Grant Fund and Startup Venture Fund, which you can have access to. And the startup is defined as you have to be a registered entity in the Philippines. Need not be a 100% Filipino-owned company, but you have to register as an entity in the Philippines. Plus, you are providing an innovative product, process, or business model. It has to be something new. All right, so that's it for my talk. I think I spent a few more minutes, but I'm happy to answer questions later. Vina?
Thank you, EJ, for your lecture. Friends, EJ just summarized at least one semester worth
Yes.
of basic IP
so
course
difficult.
in law school.
I have so much to say, but okay.
Yeah. Well, only the gifted and the genuine IP experts are able to do that. Thank you, EJ. So at this point, we transition to the events panel discussion and open forum. So in beginning this segment, we deem it best to feature some startup companies in the Philippines to introduce their work, to share their best practices, and of course, to inspire all of us with their unique stories. With this, may I call on and briefly introduce our first startup. Please welcome Mr. Noel del Castillo, founder and chief executive officer of SeeYouDoc. With more than 16 years of experience in the IT industry, Noel has managed being both a technopreneur and a professor of technopreneurship at the University of the Philippines, Diliman. He graduated with a master's degree in technology management and a bachelor's degree in computer engineering. He is the founder and CEO of SeeYouDoc, a telemedicine platform that is changing the future of healthcare in the Philippines, as well as an incubatee of the AIM Dado Banatao Incubator. They were able to file a patent application during their IP development track program with IPOFIL within the incubation program. We are very eager to hear from you, Noel. Please take over the virtual floor.
Hi, hello. Let me just reopen my slides. Share it quickly. Okay. All right. There's a sorry for that technical glitch in a bit. Um. Okay. Good afternoon, everyone. My name is Noel del Castillo. I'm the CEO of SeeYouDoc. I'm here to share an overview about our startup and our insights on intellectual property. Let me start an overview about our startup called SeeYouDoc. We are an e-health startup that is currently incubated at AIM Dado Banatao Incubator. We are a telemedicine provider that offers solutions for patients, doctors, clinics, and hospitals for their telemedicine needs. We have a healthcare marketplace where anyone can search, book, and avail of telemedicine services. And currently, we have more than 23,000 users using our platform. Our mission is to make healthcare easy and accessible to everyone by scaling telemedicine systems for both public and private health sectors, starting in the Philippines. Our journey started 2018, where we started to build an online platform for booking an appointment with any doctor. And then when the Universal Healthcare Law was passed in 2019, we developed a telemedicine system for both web and mobile application. And then when the pandemic happened, we were positioned to partner with the Department of Health in fighting COVID-19 through telemedicine. So we are still active in that partnership, and we are offering free telemedicine services uh, that is being catered by our volunteer doctors in DOH. And then on July, we were fortunate to be part of AIM Dado Banatao Incubator. And then August last year, we were one of the winners of Rescue Startups versus COVID-19. Currently, we are a partner of EPLDD in their e-health program, providing telemedicine for enterprise customers. We are a partner of St. Luke's Medical Center College of Medicine in their telemedicine curriculum. They're using SeeYouDoc to teach med students and conducting telemedicine that is patient-centric. And then recently, we've launched a telemedicine system for Mendoza in Cavite that provides free telemedicine services in their city. And then we became part of Idea Space startup community. And then part of this talk, we were able to file a patent that has a title of Medical Practice Managing Systems and Methods of Using thereof. And then recently we were able to get funding from DOST, PCHRD, to help build an analytics platform that will provide business intelligence for medical facilities on both public and private sectors. So what we have built is an integrated healthcare platform that allows patients to access telemedicine services anywhere through our main brand, SeeYouDoc. Then we have a product called SeeYouDoc MD that allows doctors to provide telemedicine services via any computer or mobile device. So we have our mobile app and a web application. And then we have a product called SeeYouDoc MC for clinics to help manage their clinic operations in terms of scheduling their patients and their doctors. We have uh, we have a call this we have a product for hospitals that allows them to manage multiple clinics and helps them provide revenue within this telemedicine industry. And then we have a product for healthcare provider networks. So this is connected with the Universal Healthcare Law that help manage multiple medical facilities. So it's a hierarchy of organization that we're able to integrate within our platform. So just to give you an overview of how it works, so in terms of patient and doctor journey, as a patient, I will be able to search online of a doctor, clinic, or hospitals, or any healthcare services I would like. So just go to our website, www.SeeYouDoc.com, and then they can book an appointment, schedule, and select a doctor they prefer. And then once that appointment has been approved, the doctor can and the patient can consult online using any device, whether a computer or a mobile app. And then during that consultation, the doctor can view the medical records of the patient. The patient can upload their medical results for prior to the online consultation, so the doctor can review it before the consultation. And then during the consultation, the doctor can issue e-prescriptions based on their diagnosis. And in terms of the payment, patients can pay online using their credit card, GCash, and GrabPay. So with regards to IP, so on the start of this year, Prim, our executive director, gave us a good news of providing us IP, intellectual property track within the incubator. We called it Think AIM Intellectual Property Development Track. It is a partnership program of the IPOFIL and the AIM Dado Banato Incubator, which is exclusive to the AIM DBI startups. So we were fortunate to be part of that program. So the idea is for us to be trained and be able to capitalize IP in terms of the creation and protection, and also commercialization of our for the startups. Our IP journey started with an introduction to intellectual property. Then there's a class about copyright, trademarks, patents, utility models, and industrial designs. And then at the end of the course, it's actually a 1-month program. So at the end of that 1-month program, we filed a patent as part of our graduation ceremony. So during that filing of patent, our mentors from IPOFIL help us draft the patent application. So as a result, we were able to acquire the trademark for our logo and brand. We were able to file a patent application for the processes and methods that we've invented within our platform. We were able to embed copyright within our source codes, and we were able to enhance trade secret protections, part of our within the company in terms of changing our governance structure. And so our vision really in SeeYouDoc is by 2025, we have established a strong telemedicine industry in the Philippines. That's it. Thank you for listening.
Thank you, Noel. That was very insightful. The vision and journey of SeeYouDoc is truly inspiring, and SeeYouDoc appears to be significantly contributing to the progress of the telemedicine industry in the Philippines. So we have a number of questions coming in, but we will ask them after the last presentation. So please keep them coming. I will make sure that they're asked from our experts and guests. So to further inspire us and give us a glimpse of what their startup is all about, we would like to call Mr. Vincent Mendoza, founder and chief executive officer of Farmvocacy. Vincent Mendoza was initially a business management student, but later on graduated with a degree in agriculture. He later on found success in working for different companies and realized that he wanted to do more. Even after an initial setback in setting up a business, Vincent persevered because he knew that uplifting the lives of farmers is an important and meaningful endeavor. Farmvocacy was officially launched on November 29, 2019, with the goal of uplifting the lives of Filipino farmers. As most of us may probably have guessed, the name was taken from the two words farm and advocacy combined together. I hope you register this as a trademark, Vincent. We were told that there was no special reasoning for the name, that it would be straightforward in delivering the purpose of the company, which is simply to be advocates for farmers. Vincent, and perhaps along with the rest of Farmvocacy, always believed in the importance of using today's resources without depleting it so that the next generation can use it. In not so many words, Farmvocacy is centered around sustainable agriculture. Let's all listen to Vincent as he shares with us more information about the startup business, Farmvocacy. Vincent, you now have the virtual floor.
Thank you for having me, Attorney Panganiban. Let me just share my screen. Yes, good afternoon again. My name is Vincent Mendoza, and I'm the founder and CEO of Farmvocacy. So our business is an inclusive business trying to bridge the gap between consumers who are looking for an environment-friendly and impact-driven rice products, and farmers who are actually taking care of the environment and also taking care of their consumers. So for the past 2 years, we were blessed to have been part of some of the supporting accelerator programs, such as the Field Dev and Innovation for Social Impact. We were part of the Impact Boost Camp held last February 2020, and we were also been blessed to have received grants from ECCP last year. Last year, we were also accepted through an accelerator program, which is Ideas Space. And we're also fortunate to be a cohort, not actually a cohort, but part of the Think Open of AIM Dado Banatao. So this year, we are officially part of the cohort 2020 of AIM Dado Banatao. So in this slide, actually beside me is Mr. Valentin. A rice farmer has been planting rice for the past 50 years using conventional farming system. The sad reality is Mr. Valentin, like more than 4 million Filipino farmers, still live in poverty. In fact, they only earn 156 pesos per day. This is just 1/4 of the minimum daily wage in the Philippines. These farmers rely on high interest loans from traders. Their current farming system produces low yield. And lastly, they have no direct access to market. So these three contributing factors are the things that we'd like to address with our business model. Our business model is two-pronged. On one hand is our grower partnership program, where we provide farmers training on high-yielding, climate-smart, and sustainable farming system using certified organic farm inputs. We then buy their produce at a higher price and process the paddy at our technologically capable rice mill partner who can actually produce rice that can compete with rice imported from Vietnam and Thailand. On the other hand, we have our community distribution partnership program that we hope can make the product available to consumers, people like you who are looking for impact-driven and sustainably grown rice. So during the program with AIM Dado Banatao, as Noel mentioned, we were able to file also a patent that will provide the third leg of our business model, which at this point, I'm not in a liberty to share, given that we're still in the stage where we need to reply with the formality examination report. Our team is composed of more than 14 to 15 years of expertise in agriculture, in finance, and in technology. Our journey started way back in 2015 by distributing certified organic farm inputs. But after learning that we need to do more, we cannot just sell certified organic farm inputs to farmers, we decided to step up to the plate and actually participate in the entire value chain. That's why in November 2019, we started developing our own platform that will connect consumers to farmers who are proud of producing sustainably grown rice. So at this point, we're in the stage of having our distribution set up within Metro Manila. And we've applied for a patent for a commodity digital exchange that will allow people who are impact-driven to invest in our business model. So during the IP development track, with the help of IPOFIL and Imdado Banataw, we got a lot of learning. That we learned that the different aspects of protecting our business using patent, that investors are actually looking for patented intellectual property. In fact, after we mentioned to an investor that we filed a patent, they were eagerly interested to meet us. So we are now in the process of signing an agreement with them in preparation for helping us develop our business further. And we also learned that intellectual property can be a competitive advantage, and learned that before disclosing an idea to investors, to a colleague, you need to sign a non-disclosure agreement. And we also learned the process of spotting a novelty and inventive step in an idea. And finally, we learned the different aspects of protecting your idea so that your startup can have bigger valuation. So that's our journey with Imdado Banataw with the help of IPOFIL. And with this, we'd like to invite you to be one with us, buy your rice, donate, or partner with us. And with technology and with your support, we can better the lives of Kuya Valentin and thousands like him. Maraming salamat po.
Thank you very much, Vincent. Really and sincerely, I wish that your tribe will increase and you will be able to maximize your IPs. May you continue to help farmers, may you continue to help consumers, and in the long run, may you continue to help the Filipino. So moving on to our panel discussion proper, may I once again call Attorney EJ Baranda, Mr. Noel del Castillo of SeeYouDoc, and Mr. Vincent Mendoza of Farmvocacy. We are delighted to be joined also by Mr. Benoit Tardy. As we gather our panelists, allow me to introduce Mr. Tardy. Benoit Tardy is the IP Business Advisor for the Southeast Asia IP SME Helpdesk project and is currently based in Ho Chi Minh City, Vietnam. Benoit is half French, half Colombian, and is in charge of advising European SMEs on intellectual property-related issues, particularly covering the Southeast Asian region. Following some scientific studies, Benoit switched to law, and he is currently holding several French academic degrees, a double bachelor's degree in law and comparative English, American studies, a master's degree in private and corporate law, and a master's degree in intellectual property and design law. He is fluent in French, English, and Spanish. Benoit worked for several IP specialized law firms in France and also had the opportunity to work for a South African law firm located in Pretoria. Welcome, Mr. Benoit Tardy. Let's start off with the panel discussion. Perhaps to jumpstart, we can ask Benoit to share some insights or comments that you may have on the presentations that were shared earlier.
Thank you very much for the nice introduction and for giving me the opportunity to speak. I carefully listened and watched the whole presentation from everyone, and I was really surprised, really amazed to see that every time intellectual property issues were discussed but also settled, we had the nice overview from Edmund. We had also some incentives and programs discussed by Mr. Gerry Constantino, also by Mr. Vincent Mendoza, and by Mr. Noel de Castillo. So I think it's always great to have like a synergy between all entities, between the SMEs, between lawyers, and between also the administrative parts, and let's say IPOFIL, for this really nice combination of forces. Maybe I have a question that Mr. Mendoza, Mr. De Castillo, and also Edmund could reply or share their comments. I know it's very
difficult. Go ahead. Yeah, please go ahead.
I know it's very difficult for a startup or a SME to pick up a name or a specific brand. I don't know if they have any advice, any comments on or tips to give to people.
Okay, let's start with Attorney EJ. Any tips for MSMEs?
Sure. Before I answer, Noel and Vincent, I was listening to your presentation and like to echo what Vina said. It's really inspiring, and as Vina said, may your tribe increase. So wish you all the best. To answer your question, we always advocate that your name, your company name, and your brand name the best would be a coined term, something that you invented, something that's part of any language, with English, Spanish, French. Come up with something that's really catchy and unique and new. It's a coined term. It shouldn't mean anything, because there's a higher chance that your mark or your company name will be registrable, because it's not similar or identical to anything that's already out there. And as I've said in my slide, do a search, a company search, and hire us lawyers to do your trademark search and advise you on whether your mark is registrable or not, and we can help you register your mark. So those are my 2 cents advice.
Thank you, EJ. Perhaps Noel can also share some tips and guidance to our would-be applicants of IP in the IPO. How was your experience?
I guess for us, the experience really trying to decide and be on what brand to use and making something unique and be and creative, because this is a brand that you would invest into moving forward. So at the beginning of a business, you really need to research on it. Like in what we did, of the first thing we did is we tried to see what are the available .com domains. So that's number one tip, because .com is the number one domain that you can really promote your brand. And if you're able to buy that domain, then you need to build on top of that. So if you see that your business is already thriving and you have customers and you want to protect your brand, then that's time you file for a trademark. So that's my advice. I love to share more, but I believe maybe Vincent can also share something.
Yes, Vincent, please. Any tips?
In our experience, before we joined the intellectual property development track, to be honest, I was hesitant to join, because I thought at the time, what am I to protect? It's so simple what I have in mind. And then during the 1 month program, I realized that basically I want to go to give advice to everyone. No? If you think that there's nothing to protect in your idea, you'll be surprised. So know what you can protect, know what others have already protected, and spot which is noble and inventive, and hopefully you can monetize the protection. So in other words, let's not belittle or maliitin yung our ideas. And one thing I also learned, never openly share your idea. Sometimes we're too excited, not knowing that the other party have already protected it. So that's all.
Yeah, that's right. I completely agree. Do not belittle your idea. It appears that you already examined, you already went through your own personal examination of your own application. So don't do that. Don't downplay it. It may be a great idea for all you know. So thank you for sharing your very inspiring stories about protecting your IP. Okay, we now proceed with the questions through the Q&A function. This is probably addressed to EJ. EJ, seasoned investors or VCs would say that NDA agreements are not customary anymore in tech hubs like the Bay Area. If they will not sign an NDA, are there any other ways that their ideas or IPs can be protected?
I think it's a great question, and it's really what's happening in the real world. Again, I mentioned earlier the imbalance of power between the startups and the possible investors. It is true, and also in my experience, some possible potential investors, because they think that you need them so much, they will say, no, we're not going to sign this NDA. My advice is find a way to convince them about your product without disclosing details. What I mean is that just give them what it can do, but not how it's done. Discuss in general terms what your product and what your service can do, but do not disclose how you can do it. Because if you disclose it to them without them doing an NDA, then they can just turn to their own, to their own inventors, to their own tech people and say, hey, I got this great idea from someone. Maybe let's just develop it. We don't have to license it from them. So that's how you protect yourself. If you cannot insist on an NDA, then just be very careful with the words that you say to the possible investor. Maybe Benoit, who has a lot of experience on this, can say more.
Yes, Benoit,
sure.
Please.
Sure. For the NDAs, it's I know it's always tricky. You said it, Edmund, because you have the positive way that you want to share your information, you want to share maybe your technical solution, and also to attract investment. But at the same time, you really have to be careful about what is worth revealing or just keeping the information. And we were discussing during the presentation about trade secrets. It can be also an additional step to protect the valuable information of the company. But basically, with the virtual era, because of the COVID, we also see a lot of information being revealed during Zoom and any other meetings. And I have to remind people to stay alert also on these virtual meetings, that still you have to keep track of what you're disclosing to others.
Thank you, Benoit and EJ. That's really free legal advice from our lawyers in the
If I may add.
Yes, go ahead, Noel.
Yeah, for startups who are doing fundraising, when you do initial pitch, normally NDA is not really required. That's why the pitch needs to be very brief. But if you're going to the next level of due diligence, then NDA will be a requirement. And if you are going to a due diligence with an investor that will not sign NDA, I would not recommend that.
Very well said. Vincent, any inputs on signing of NDAs with your partners?
Yeah. Before we finished the IP development track, I thought that nobody, because I heard it before, nobody will sign NDA. But I was surprised. Actually, the investor that we get to talk to, they were willing to sign an NDA. And in fact, with our next step, they're giving us an NDA also. So I think just don't think so much in advance that nobody's willing to sign it. And protect your ideas.
Yeah, well, I think any self-respecting business will agree to sign an NDA. Only, the bullies and those who would like to take advantage of the small players would refuse to sign the NDA. So speaking of the refusing to sign an NDA is actually a bottleneck. But speaking of bottlenecks, there's a question here. Are there bottlenecks that you can identify in terms of applying for IP in the Philippines? I'll start with our startups, Vincent and Noel. What types of obstacles did you experience when you filed your patent application? I heard that Vincent had received a formality examination report from the patent examiner. Perhaps you could share your experience. What kind of obstacles did you encounter when you filed your patent application?
It's actually my first time to know more about IP. So, and I learned also that it's expensive. It's expensive to do the process. So, one thing I learned is that learn as much as you can. If you can learn how to file yourself, do it. And when you receive formality examination report, that's the time you decide if you need a lawyer or not. So we're in that in that crossroad.
Okay, yeah, that's good. Yeah, and very practical actually. Noel, any inputs on how did your patent application turn out with the IPOFIL?
Well, actually, it went well. If you have like a sense of fear that there's gonna be red tape or some kind of corruption, there's none. IPOFIL is very straightforward. They have a good system in place. The only challenge really is learning the language of how to file a patent, because you'll be surprised. You need a lawyer to help you or someone to really translate some of the things, the concept that you practically know, but the terminology is different on the patent or in the IP industry. So, I mean, in our experience, we were very fortunate to have IP development track in AIMDBI. We have mentors from IPOFIL who really guided us on our patent application, who help us translate the methods and processes, and how to really decompose of these things and choose which one we should patent that is very unique within our software. So that's it. You can really seek advice from them. So we have people like in this particular program. We have people here who can really help startups on their patent application.
Okay, so Noel, while you're on the spotlight, there's a question here for you. How has telemedicine grown since before the pandemic? Has this posed challenges in maintaining your IP?
Well, the pandemic really made a big impact in the telemedicine industry, not only in the Philippines but around the world. So with regards to competition, it's very competitive. You would be surprised. There's a lot of new players now in the industry. This is where IP comes in to be an asset for your company to stay competitive in the market. Because being in the tech industry, expect a lot of competition. But if you really smart enough to understand how to protect your IP and how to strategize your way around your competitors, and then you'll be in the business. And since the market is growing, there's a lot of pie to share for all of us in this industry.
That's good. EJ, are there changes in IP applications during pandemic? Can everything be filed online? And perhaps Benoit can also give a Southeast Asian perspective to this question. But EJ first for the Philippine practice.
Yes, definitely. Actually, the IPOFIL accelerated their online filing processes because of the pandemic. And we were actually, before the pandemic, we were one of the firms who were lucky enough to test the online filing system. So parang good timing then that when when we had the pandemic, then everyone was forced to work from home. So yes, good news is you can file your patent applications or trademark applications online. You just have to register. You just have to. The more challenging part really is the payment facility, because you need to partner with some payment facilities so that the IPO fill can accept your payment. So yes, you can. Even the prosecution of your application can also be done online. So you can be anywhere in the Philippines and still prosecute your applications with the IPO fill.
That's very encouraging. Benoit, how about the other countries in the Southeast Asian region?
Well, what we've seen is also going in the same way as Edmund just said, is that in Southeast Asia, with the pandemic going on, a lot of IP offices took the time, energy, and all efforts to improve their IP internet websites, but also all IP services. What we can see that not all IP offices have a full translated, accessible website. Translated in English, but it's a great improvement for many IP offices. And I would add that there are also some extra deadlines for applicants if they have some serious issues with events related to the pandemic.
Thank you, Benoit. EJ, how about training modules? Is it covered by IP registration?
Training modules are copyrightable material. So so any module that you produce, so it would be internal or external, those are copyrightable subject matter. And like I said earlier, you don't have to register it. Just make everyone aware that you're claiming copyright over that, and just the symbol C with the copyright, C with a C encircled C. Just put it in all your on your modules and say, copyright, all rights reserved, and then your company, and then the year. That's how you protect your copyright.
Okay, there's a question here. Are there differences for IPs filing when product is available online or or via app? Maybe EJ also?
If it's already made available through the app, then that's no longer novel, unfortunately. So like I said earlier, before you release any product, any service out into the world, whether offline or online, file a patent application first. And you don't have to hire a lawyer. You have to hire a patent agent. So they're not as expensive as lawyers. So I would recommend that. Talk to a patent agent first before releasing anything online or offline.
Thank you, EJ. Benoit, this is probably for you. Are there some information on how the Philippines fares in terms of IP protection in the region?
Yes, in fact, we have a very nice country fact sheet on the Philippines, but we also have on all the other 10 Southeast Asia countries. And I guess we can also find some very useful information on the IPOFIL website, but we'll be very happy to share the direct link to our country fact sheet. And it displays a lot of very updated and relevant information on each IP rights available in the Philippines.
Thank you, Benoit. EJ, what value and protection does copywriting software give to an organization?
Okay, copyright software is copyrightable subject matter. It's not yet patentable here in the Philippines. And since it's a copyrightable subject matter, once you created your software, that's already protected from the moment of creation. Do what Noel's company did. They inserted, they made sure, like that's what I said earlier, claim ownership of copyright over your software. So before releasing it to anyone, make sure that they know, they're aware that you're claiming copyright over that. Copyright protection is important because it's the only way you can enforce against someone who wants to copy your software. So, in fact, I will go further. If there's a way you can protect that through a patent, that is what I mean is combining your software with hardware And there are ways to do that. Again, talk to a patent agent on how to do that. That would be even a more powerful protection than copyright. So go for patents, a combination of copyright plus machine.
Again, free legal advice from Attorney Baranda. Okay, we have a very good question here, and which is probably a very good final question for all our panelists. Many startups have potential for IP, but they do not apply. Cost aside, for what reasons do you recommend that startups file with IPOFIL? Let's start with our guest startups. Vincent, please.
Sorry, can you repeat the question again?
Okay, so are there good reasons for you to recommend that startups file with the IPOFIL? Because some startups have the potential for IP, but they do not really apply. So perhaps some encouraging words from Farmvocacy to inspire our MSMEs out there to apply for IP.
Yes, definitely. If you think you have an innovative idea, it will always be best to have it protected, because a lot of investors are looking for a business that can run in a long time without competition coming in. So that will really differentiate your product, and especially if you patent it. So I highly recommend you file protection, because that may be your ace when you're talking to an investor.
Very well said, Vincent. Thank you for that. Noel?
Well, my advice for startups is don't live with regret. So if you fail to protect your IP, it'll be a regretful experience. Because in business, IP has a role on being competitive in the market. You'll be surprised. You may be successful a certain period in time, but even though you're the first one or the novel inventor of your product, someone will copy it and file a patent before you, or something like that. So I don't advise for anyone to leave at that certain moment, right? There's different types of IP. So there's trademark in protecting your brand. So that's very simple. For copyright, you can at the moment of creation, you can copyright and own your IP, your source codes. And then patent's really the hard one. To be honest, it's like the daunting IP, but you'll be surprised. It's the one most valued once you have one. So learning how to file a patent it says a lot about the entrepreneur, so that investor will be able to trust your company.
That's very sincerely articulated, Noel. Thank you. Attorney EJ, final words and inspiring words for our MSMEs.
Okay. I just want to add to what Noel and Vincent said, that without a protected IP, I don't think investors will be interested in your startup company. So it's really crucial that you invest in protecting your IP. And worse, if you don't protect your IP and someone else's protects the IP that you generated, maybe through a patent, now you will be the one who's infringing their patent. So imagine the trouble. I mean, you were the first to come up with the technology, and yet you are being sued for using that technology because someone else patented it. Okay. Let me end with this. A lot of companies think that patenting is really expensive. Well, yes, it is expensive, but the good news is there are ways to get funds to patent your product. And I wanna a big shout out to the DOST for offering this chance for SMEs to protect their IP. You can go to the DOST. They have a program there. They can fund your patent application. I mean, not just locally, but even internationally, if they think that it's worth your invention is worth protecting around the world. And also there's the Innovative Startup Act, which again mandates there's a fund that has been developed, that has been created. So I think we can also tap that. So it's a matter of sourcing your funds. So don't think about the costs first. Think about protecting your IP and then look for the funding. I mean, there are many ways to fund your patent application. So yeah, thanks, Vina.
Thank you so much, Attorney EJ. And final words from Mr. Benoit Tardy, please.
Well, I guess Edmund already said almost everything, but I would just stress upon, yes, it's important to register your IP for enforcement. It's also important for increasing and maintaining the reputation of your brand and all your company towards consumers and third parties. And last, I would say the investment part. Yes, there are funds either from local in the Philippines or from the European Union. And there are also ways to generate added value and to generate revenues with, for example, a patent. So just think about registering your IP rights, and the sooner the better.
Thank you very much, Mr. Benoit Tardy. Okay, so time flies when we're having fun. Unfortunately, we've reached the closing of our webinar. We hear it loud and clear. Innovation is really the key. Our startups here are champions of innovation. But when you talk about innovation, you cannot afford to talk about not to talk about IP, because IP is a great equalizer that allows fair competition for small businesses. Once again, I would like to thank our speakers, Mr. Benoit Tardy, Mr. Noel del Castillo, Attorney EJ Baranda, and Mr. Vincent Mendoza. Thank you also to our attendees for staying with us up to this point. And that concludes today's webinar. I hope you enjoyed this webinar as much as I did. I encourage everyone to continue to be involved in important dialogues and initiatives on advancing innovation and intellectual property rights and supporting market development towards economic recovery. Until then, have a pleasant rest of the week. Thank you.
Thank you. Bye.
Thank you. Bye-bye.
Thank you.
Thank you.
Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalisation by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
Vielen herzlichen Dank.
Merci à vous tous.
Dankeschön.
Merci.
Merci. Merci beaucoup.
Děkuji. Lange Tag.
Lange Tag. Danke.
Dankeschön.
Tak.
Thank you.
Dankeschön.
Ačiū labai.
Agiamanak.
Agiamanak.
Thank you.
Goy.
Daghang salamat.
Daghang salamat.
Daghang salamat.
Maraming salamat.
Maraming salamat.
Maraming salamat po.
Salamat. Daghang salamat.
Daghang salamat.
Daghang salamat.
Salamat tayo.
Madamugid nga salamat.
Maraming salamat po.